foremost, welcome to the 2024 CNC Connect Conference. It's been 5 years since our last conference, and it's great to see everybody. For those that don't know me, my name is Cord Fowler, President of CNC, and again, I'm happy everybody's here.
Hey everybody, Murphy Buggs here with CNC. I'm the Property Training Manager. We're here at CNC Connect 2024. We've had some great guests. We've had some breakout sessions on the flood and the property side, getting ready to start our general sessions this afternoon. So we're really looking forward to that. There's been a lot of CE credits that's been offered and great exhibitors with great vendors that we've partnered with for this conference and in future endeavors throughout our claims handling process.
Hi, my name is Craig Kepner. I'm a new independent adjuster. It's been a fantastic experience. Really, the sponsors, the leadership here, the knowledge that I've been able to pick up, but then really especially really connecting with the other new adjusters.
The speakers have been fantastic. We got a chance to see a lot of people that we would never see, from the insurance commissioner of Alabama, to Hal, the weather guy.
The favorite part, well, it has to be, getting to see everybody. I know with COVID, there weren't very many opportunities, and I love to make new friends and see some of the faces behind those phone calls that I've been having here for about the last year or so.
The conference was awesome. It was well put together, very well organized, and the conference would mean nothing without the people. So the people that were here were awesome as well. All of the classes were very informative. It was easy flow from one classroom to the next, and the information that we got was very pertinent to what we do every day.
So the CNC Connect really, brought everybody together. Just like Mr. Fowler said, it's about connect. And the connection that we made at this conference is really gonna go beyond this past 3 days.
We just wrapped up day 3 of our conference, CNC Connect 2024. We had a fantastic conference. Today was our certification day where we did a lot of carrier-specific certifications. It went great, went fantastic. Want to do a big thank you to all of our sponsors, obviously all of our attendees, everybody that made this possible. Please follow us on all of our social media platforms as you look to stay connected with us throughout 2024.
I've worked with CNC since 2008 at Hurricane Ike. I've done, I believe, 7 or 8 hurricane deployments with them. My experience with CNC has been nothing short of amazing. Anytime CNC asks me if I'm available, I always say yes. They are my #1 choice anytime I'm going to be deploying for a major event. They are trustworthy. I love working with them.
I've been working on Hurricane Ian flood claims for the last 6 days. This is my first year working for CNC, and it's been a great experience. I've had so much support and so much training through so many different people at the company. If there's one person who can't help me right away, they'll get me to somebody who can, and that's been the main reason why I've wanted to stick with CNC this year, is because of the amount of support that they've provided, and they're really helping me excel.
When I think back to where we started, there's one thing that still is a thread in the lining from where we were, where we started till now, and look at that as family-run business. The family values, the goal to respect everybody as individuals, treat everybody as family.
It's just how much people love to work here and love being here, and the commitment that they have to each other and the commitment they have to the company. I can't say that you found that in all places. I'm sure you do find it at some places, but man, we've got people that work here 2, 3, 4 o'clock in the morning deploying people. They never complain. They never ask for anything special. I think that's definitely a great example of an aha moment that people really do love being here, and they love what they do. And when you have that type of team, then to me, you can accomplish whatever you want to accomplish as a team.
The minute you walk in the door, you're gonna feel welcomed. You're going to see a smile on people's faces, and you're going to feel like you're home. I have for 17 years now. I have had that feeling from day one, and I still have that feeling.
It's the family atmosphere. I mean, you're going to hear that from everybody that's here. It's the family atmosphere. It's being a part of something and having the opportunity to grow. It's all about what you want to put into it.
Hey, good afternoon, everybody. Welcome back to Season 5 of Claims Corner, Episode 5. This episode title is When Attorneys and PAs Join the Party. We're talking specifically from the flood side of the house today. Property side, obviously, we deal with PAs and attorneys, a good bit as well, but we're talking from more of the flood perspective today. So I'm clearly not the expert in this field. Aaron and Julie and our two amazing guests that we're going to have on today are. So I'm really looking forward to learning things, again, from their side of the aisle. So quick introductions. Some of you may have seen us in other content before, whether it be Claims Corner, New Adjuster Podcast, training classes, things of that nature. My name is Murphy Buggs. I'm in the Property Training Department. Joining me today is...
Yeah, I'm Aaron Reed. I'm the Flood Training Manager here at CNC.
I'm Julie.
Go on.
I'm the assistant trainer here at CNC.
Good deal, good deal. Again, we're super excited that you are joining us today. We got two fantastic guests that we will introduce here shortly, and Julie will do so. But just a couple housekeeping items before we get started. CNC obviously has their own official YouTube channel, CNC Catastrophe and National Claims. We ask you to subscribe, hit the like button, turn that bell icon on as well, so that way you can get notified of any future environments of when we go live, post new content, so you stay up to date and connected with us throughout 2024. So, call to action, though, for our listeners. Obviously, we have a lot of content out there. Training classes, Claims Corner, New Adjuster Podcast. Stay up to date on those. We're always pushing out new information for all of our folks, and we're looking forward to adding more throughout this year. Again, if you've missed any of our previous episodes of Claims Corner or any of our other content, go back and give them a watch or a listen wherever you get your podcasts and or broadcasts. So, Julie, do you want to go ahead and introduce our guest today?
Absolutely. Today we have joining us Miguel Perez, who is the Vice President of Claims and Litigation, overseeing Write Your Own and NFIP Direct for Torrent. Along with him is Elaine Anderson, the Claims Manager at Torrent. She and her team are responsible for handling the Write Your Own. So we're going to start off with Elaine, and my question for you is, you've been doing this for a long time. So do you have any particular time where you dealt with a PA or an attorney that kind of stands out to you?
Yeah, I do have a story I'd like to share. Thank you, Julie. I get requests from PAs all the time to set up meetings, make phone calls. For some reason, they think the manager is going to solve all their problems. So recently, I had two gentlemen who requested that we set up a meeting. So I did. It's a Hurricane Ian wrap claim, condo building, complicated claim. I kind of explained the wrap process to these PAs. There's two of them on the meeting. And they asked me to reach out to the policyholder and get all of this information that I just told them I needed to support their claim from the policyholder. And I was kind of taken aback. And I told them, I've worked with a lot of public adjusters, and this really isn't normal. Normally, you guys are involved in helping your insured. And really, you're doing a disservice to the policyholder with this approach.
Right.
At which point they told me, ma'am, we're not public adjusters, we're the broker. So I bring this up for three reasons. One, don't be scared to talk to public adjusters. Two, sometimes you have to have a hard conversation with the public adjuster, right? That's part of the job.
Mm-hmm.
But three, know who is involved in the claim, because there's a lot of people that present themselves as a representative, but aren't. Could be another party to the claim or another person helping out the policyholder. So all three of those things we're going to discuss in this webinar, and I'm excited to get into it. So let's go.
All right.
Yeah, that's good stuff, Elaine. So, Miguel, this next one is for you specifically. Maybe not necessarily a story, but what's a unique challenge you are faced from your perspective and even the flood adjuster's perspective when you have to deal with a public adjuster on a particular claim or a claim file?
Thank you, Murphy. It's perfect timing for this question, as we're a year and a half after Hurricane Ian, who caused heavy damage to the Fort Myers area. We're now in a time period where a year and a half out, we're getting close to the deadlines of filing a lawsuit or going into litigation on unsolved Ian cases. So big challenge we got going on now is, I want to say probably 99% of the public adjusters and attorneys that are representing our policyholders on these Hurricane Ian cases are property and casualty public adjusters and attorneys, and do not have the NFIP experience, do not know the federal regulations, and are approaching um, the write your own carriers with a lot of state regulations and state statutes that do not apply to federal law. So that's become a big challenge for the flood industry in today's day and age.
So basically, what you're saying is really just an inexperience level, or not knowing the federal side of things. They come in with more of the state side, the limitations, the statutes, and things like that.
Yeah, I'm sure they're successful attorneys and public adjusters. However, they are not up to speed with the NFIP regulations, or not familiar with them. A lot of attorneys and public adjusters come in with high demands, threats, and demanding a lot of items that are not allowed by the NFIP or federal regulation. They're more, having a PMC background, familiar with what they're doing, because it's more of a PNC approach, which is completely different to the NFIP, and big difference too. NFIP is governed by the federal government, so all the local states, in Hurricane Ian's case, the state of Florida, laws and statutes do not apply or are not governed by the federal government.
Right. Yeah, that's a good point. That's a good point. So, Aaron, I'll pose this next one to you. They've spoke about it from Torrent's perspective. Elaine and Miguel both have. From an adjuster's perspective, why is it, do you think, adjusters are reluctant to speak to an attorney or a PA? Is it the anxiety factor? It's the unknown, the not knowing how to handle it? What would be your answer to that, do you think?
Yeah, I think, in my experience, what I've seen in the past is adjusters can feel intimidated really with when a public adjuster is on a claim. And it all goes back to the confidence that you have in your knowledge of the policy.
Mm-hmm.
If you're not, or if you feel like you're not very knowledgeable and you're dealing with another professional in the industry, and they are, you may feel at a disadvantage there, or you may feel like you have to have your defenses up whenever you're talking to a public adjuster.
Sure.
But in reality, talking to a public adjuster is just like talking to any policyholder on any claim. The goal is still the same, to get the claim to closure. Everything is pretty much the same.
Yeah.
There may be a few differences with, like, having to get a letter of representation for, in order to talk with a public adjuster. But as far as how you talk to them, the information that you go over with them, I would say that it should be the same as any other claim.
Yeah, so I get what you're saying. So that your talk path is really the same. There are just some other formalities, legalities in place to where letter of representation is needed. There's certain things that you have to say according to law, federal law, when it comes to a flood claim, correct?
Yeah, and that kind of goes back to Miguel's point on what law governs the flood policy. I know that if you're not well versed in the flood policy and understand what law actually applies to the policy, then it can be intimidating when you have an attorney or a public adjuster come in that quotes state laws that you're unfamiliar with and you don't know how to respond to them.
Yeah.
So that reluctancy there, it can come from, a lack of confidence in what law governs, a lack of confidence in your knowledge of the policy. But I think that there should not be any reason to be reluctant, or there shouldn't be a reason to be reluctant to talk to a public adjuster or an attorney. It should be just like any other claim.
Yeah, understood. So, Elaine, I'll kind of pass this one over to you here. Obviously, we talked about it. Really, it's the same as any other claim. However, let's discuss some of those distinct requirements that when you have to deal with a PA on a flood claim, most specifically.
Yeah. The first requirement is not our requirement. It comes directly from FEMA per bulletin W18012. If you don't have that bulletin, have it, print it. This is a public document, so you can share this with your public adjusters and attorneys you're dealing with. You can share this with your policyholders, but there's very specific requirements that must be met in order for them to be recognized as the legal representative for the policyholder. I'm not going to go through all of the requirements. One that we see a lot is you have multiple insureds on a policy. each insured has to agree and sign with the requirements on the bulletin. If just one party does it, but there's multiple insureds, it's invalid. So
Okay.
make sure that you're looking out for that. Um, the public adjuster will never be, or attorney will never be named on a claim check. A lot of their demands are going to request that we do that. FEMA does not allow that under this program. You can certainly send the check to their office. You can request the write your own, mail the check to the public adjuster, but they won't be listed as a payee. That's a big difference. Um, any correspondence that we produce on our end, on the write your own side, so any of our letters, we can send them to both parties, both public adjuster and insured. In fact, we encourage that we keep both parties updated with all of the information that's being provided. The other thing is that per this bulletin, they can request the entire claim file. That includes all of the adjusters' reports, all of our correspondence, copies of checks, things of that nature. So keep in mind as you're doing your reports, we want to make sure that they're thorough. We want to make sure that they are well documented, but you also don't want to put anything in your report that isn't relevant to the claim because it ultimately could be discoverable outside of litigation. They can still request an entire copy of the claim file. So just something to be aware of, a little differences when you have a public adjuster representing your claim.
Yeah. So piggybacking off of that, something that you addressed there was that each policyholder that is listed has to be in agreement with that. So Miguel, can you speak to this? What happens in the case where one of those policyholders does not agree on with the letter of representation? They don't want to go with the PA. Does it make the whole thing invalid? I think that's what Elaine said, but am I right there?
Yeah, it won't, it'll keep it invalid. We can still communicate with the insured. And as Elaine mentioned, that representative, per the requirements of the NFIP, are not a legal representative for the policyholder.
Yeah. Because we even see sometimes, I'm speaking specifically on the property side, where policyholders get represented by a public adjuster, but then they turn around and a week later they want out. Do you see that happen on the flood side as well? This is for Aaron, Miguel, Elaine, any of you.
I'll take that. I've seen a lot of situations where the public adjuster and or attorney uh, come into the situation, meet with the insured, make a lot of promises of how they're going to take care of the claim. You know, you weren't taken care of by the adjuster. I'm the attorney. I'm going to take care of it for you. I'm going to get you policy limits. I'm going to get you A, B, and C. They send in their letter of representation. They reach out to us. They communicate with us and or the field adjusters, the examiners, knowing this is an NFIP policy, without having the complete story from the policyholder.
Right.
Mostly always, our team, our examiners, our field adjusters have been back and forth with the policyholder, explain everything, explain what's covered, what documentation is needed, what restrictions apply, what's not covered, and don't explain all this to the attorney or the attorney. We're not there for these conversations, but I'm assuming some of the conversations are, don't worry about that, I'll take care of it for you. They come to the carriers with the bully tactic or the big demands, and it's rare to get a demand from an attorney that we could work with. It's mostly something that's just way out of the scope of the policy.
Sure.
Over policy limits, clearly not covered. It's just not much we could work with.
Yeah.
So that gets a little difficult because we don't want to come off as we don't want to help, but we've already gone above and beyond to help this policyholder. And now the attorney's bringing it back and making all these inappropriate demands that the policy won't pay for.
Sure. For Aaron, oh, sorry, Elaine, go ahead. I didn't mean to interrupt you.
No, I just want to add a quick caveat too regarding the bulletin. Let's say your letter of representation is not in compliant. You still want to have some conversations with the public adjuster. This is a good opportunity to educate them on the NFIP program, the claims process. Unfortunately, when the letter of rep is not in compliant, you can't really discuss claim specifics. So you can't talk about a specific claim, but it's still a good opportunity to have conversations with the public adjuster about this policy, right? The policy you can talk about, and about other requirements that we may need from the public adjuster to then be considered their legal representative.
Right. Aaron, have you ever, I know you've got a lot of experience as a flood adjuster too. Have you ever found yourself almost coaching the representative?
Yeah, absolutely. I think that's, one of the challenges with when a PA is representing a claim, kind of piggybacking on Miguel's point there. Whenever they come in later in the process, there could be things that have already happened on the claim before they got involved.
Right.
And basically getting them up to speed, clearly communicating with them, and then when a public adjuster does send in their estimate or they send in a demand letter or anything like that, taking the time to really break that down, and if they are requesting something that is outside of what the policy covers, really taking the time to explain the NFIP processes and coverage, doing that as quickly as possible on the front end, that can go a long way with helping the process overall. Later on in the process,
right,
to help it move along.
Right. So. Sure. Okay.
All right, Murphy, I want to add a little to that. So once we have these conversations with these attorneys, these initial conversations, we go over the demand, go over what they're asking for, and we explain the process, explain a few things. The NFIP does not allow for attorney fees, which is always in their demand.
Right.
The NFIP does not allow for a trial with a jury, which a lot of attorneys push for to put a corporate representative in front of a judge and a jury in federal court to get a judgment. That's not allowed by the NFIP. And we also explain everything we've done to help the policyholder.
Right.
At that point, very common for the public adjuster or the attorney to withdraw their representation.
Really? Okay.
So they back out and withdraw because there's nothing in it for them, or they confirm things have been handled, or you just don't hear from them again.
Right. Huh. Do you find that a lot of policyholders are taken back by basically getting that withdrawal from the public adjuster or attorney when that happens?
We're not there to see those reactions.
Right. Yeah.
But it's unfortunate that, we're not there, but we're assuming, and we've talked about this in the past, we're assuming some expectations are set, right? Hey, like I said earlier, I'm the attorney, I know what I'm doing, they're not taking care of you. They make XYZ promises, and then they can't deliver that. So, I'm assuming, none of us from the claims perspective are in these homes or these attorney offices when these agreements or conversations are happening. But I'm assuming there's conversations like that. Yep, they didn't take care of you. I'm the attorney, I'll take care of you. And then, there's a huge demand. Through the process, we find a small supplement because, our estimates are undisputed amount. Our team does a good job writing estimates, but there's always something we miss, right? When we do a re-review.
Right.
So you might have a 6-digit demand in addition to what was already paid, and you're coming back with a small supplement of, $5,000-$10,000. So I'm sure there's some kind of conversation or disappointment there.
Right.
But looking at the policy, having those conversations, looking at the estimate, looking at the damages, what's covered, our team has done everything that should have happened in that claim per the NFIP guidelines and regulations.
Yeah, it sounds to me.
Ultimate everybody's job here, right?
Right. Yeah. To me, it sounds like the classic overpromise, underdeliver. In those aspects.
I'll say one more thing there, kind of going back to the educating the public adjuster. A lot of people are not aware that the flood policy is an incurred cost policy. And so, I see it all the time where they come in for a supplement claim and a public adjuster or attorney is, they get into the debate of, whether certain repairs are needed on an estimate or not as a way to get more money out of the claim when in reality, we can address the policyholders' contractor estimates or whatever their incurred cost documentation they have, the actual cost of repairs. Whenever I tell public adjusters or attorneys that we can address their actual cost, and the initial estimate that we prepare is not just a this is the estimate, this is all you get type situation. We always have the opportunity to go back and address incurred costs. Then typically having that conversation with them reduces the amount of arguments over individual repairs that need to be in the estimate.
Yeah. Julie, you want to take us into our next one?
Yes. So Miguel, how does handling differ when an attorney is involved? We've talked about the PA and the letter of representation and the communicating with them and the policyholder, but when you have an attorney on the file, what do you do with communication?
Great question, Julie. So nothing changes in the claims handling, in the process, or in the coverage.
Right.
At the insurer's request, through their legal representative, will communicate directly with the attorney and the public adjuster.
Okay.
But hiring an attorney, hiring a public adjuster is not going to get you any more money than you're owed by the policy or anything special.
Right.
We're still going to follow the guidelines and pay what's owed. No more, no less.
Right.
Right. But with an attorney, the adjuster or even the claims examiner, they should really only communicate with an attorney, right? And not the policyholder?
That's the most common request.
Okay.
When you get a letter of representation, typically there's language on there to communicate directly with the attorney.
Okay.
There's time to time where we get a call directly from a policyholder, even though they have a representative, or they're both involved because the policyholder's working with our adjuster and the attorney to provide supporting documentation to justify their demand, their claim, or even a supplement.
Right.
Okay.
But good rule of thumb, right, Elaine, when it's an attorney, straight through the rep, right?
Straight through the rep.
Yeah.
Yep. And I just want to mention too, not that you guys on this call don't know this, but all of this guidance that we're talking about is also in the NFIP claims manual.
Yes.
So highly recommend that you guys reach out to there if you're, if you're unfamiliar with some of this guidance. FEMA publishes great guidance as well on how to deal with public adjusters and attorneys.
Yeah. So this has been good stuff. Let's segue. Let's kind of stop part one for now. Let's do a quick segue into our IYOW segment of the week, our In Your Own Words segment. It's something we've been doing on Claims Corner this year. Season 5, we're excited about it. We got the graphic and everything, so it's official now. So this week's IYOW segment is brought to you by Blue Leopard Agency. It's a marketing agency that's redefining success in the digital age. Visit blueleopardagency.com today to discover how they can tailor a marketing plan that's as unique as your brand. Don't wait. Take the first step toward marketing success right now. So Elaine and Miguel, we'll let Miguel go first, then Elaine. Our question of the week, in your own words, and you can be as honest and as transparent as needed. What are your initial thoughts? How do you feel, personally, I guess, when you see that a claim is represented by a PA or an attorney? And again, you can be honest. This is a safe space.
I'll go first. Does it make a difference for me personally? In some cases, I'm glad that some policyholders hired a representative.
Yeah.
Because our adjusters have probably just hit a wall where we're not making progress, or there's some kind of dispute. They're not understanding the language, and hiring a representative that could review the policyholder side, review the policy, review the coverage, and go back with affirmation that everything's been taken care of based on the guidelines. That seems to help at times as well.
Yeah, that's a good point. Elaine, what about you?
Yeah, I was going to say the same thing. There's some cases that come across your desk and now they have a public adjuster, and your first thought is like, oh, thank God. Now I can work with this public adjuster and maybe get somewhere with this claim. Like the one I mentioned at the start of the webinar with the brokers, this is a claim that could probably use a public adjuster. It's a very complicated condo claim.
Yeah.
But really, whether they're represented or not, it's indifferent to how the claim is being handled. It shouldn't make a difference as far as what we're doing or what our adjusters are doing out in the field. It's still about following the rules, the program, providing the best customer service possible.
Yeah. I like the answer that both of you gave, too, that it doesn't necessarily make a difference. I think a lot of times adjusters, Aaron, you can speak to this, too. A lot of times adjusters see that a claim is representative, the anxiety level goes up, the heart starts beating fast. I mean, do you obviously see that from flood adjusters, too?
Right, yeah. Like what was said earlier, it can be intimidating, I think, at times, but
yeah.
The reality is it's exactly the same. It should be. You should feel indifferent whenever you see a public adjuster because nothing changes.
Right.
All the processes, all of our coverage stays the same. Everything stays the same. There's really no difference.
Yeah, and I think good takeaway there, too, what Miguel said as well. Sometimes the adjuster has ultimately just hit a wall, and sometimes this might be the breakthrough in getting that claim to closure. So, yeah, that's a very good point. Good IOW segment. Part two, let's jump into this now, Miguel. Communication is huge in any claim. We all know that. We've dealt with claims for a long time. Communication is the key to having a successful and efficient claims process for all parties involved. How can an adjuster effectively communicate with a public adjuster? What are some tips, some tricks? What should they do in that aspect?
Yeah, great question. So my recommendation when we get a demand like this is review the claim, look at their demand, review the claim, get educated with what's happened in the past, what happened with the claim, where's it at today, what's pending, what's missing, is there a supplement, is there something lingering or something that we need to take care of. I love to pick up the phone, have the conversation with the attorney. We received your demand, and kind of do a few things, right? Introduce yourself, establish a point of contact, go over what they're demanding or what they're asking for. Have that conversation. Hey, I know you just came into this, you were just hired. The items you're demanding were previously addressed, or now that you're involved, and we've talked about this earlier today, now that you're involved, can you help us? Can you facilitate us in getting this supporting documentation that we haven't gotten from the insured?
Right.
Chances are the policyholder hired a public adjuster or an attorney for help or for the next step of escalation, to get what they want. Is it covered, not covered? Are we pending documentation? We have those conversations with the insured. All the FEMA publications all the FEMA documentations are public. The claims manual, the 3 policy forms are all public records. All the bulletins are public records. We share that with the attorneys, the public adjusters, and very important to have those conversations. Explain how the NFIP works. Explain what term they demand, what's pending, how can we move this to resolution. Of course, follow up in writing, as per our conversation email. It was a pleasure speaking with you. Here's what we're missing, or here's what we cannot cover, so on and so forth.
Right.
And I know this was said earlier, a lot of adjusters, maybe newer adjusters, are intimidated by attorneys and public adjusters. I'm gonna tell you right now, guys, you don't pick up the phone and talk about it, it's gonna get worse.
Absolutely.
When you get a demand, even if it's a ridiculous amount, that you open it and you just roll your eyes and they're like, this is never gonna happen, you gotta pick up the phone and have that conversation. You cannot ignore it.
Right.
If you ignore it, you're gonna get in trouble. This case is gonna end up in litigation, and it's gonna cost us a lot of money to deliver the same message we could deliver for free in 5 minutes today.
Yeah, that's a very good point. Very good point. And I think to your point too, everything goes in writing. Right, Elaine?
Yeah,
everything goes in writing.
Always. So we've talked about PAs and attorneys, but there are some times when when policyholders have someone else represent them. Elaine, who else do policyholders get to represent them?
Often we get requests from the agent, the broker, and these can be our best allies in working a claim.
Absolutely.
So we want to maintain those relationships with them and maintain open communication with them. With the agents and the brokers, we can disclose claim information. We can give them like payment amounts. We can give them names of, hey, this person's repped by a public adjuster. Here's their name and phone number, or attorney. So the agents do have a little bit more leeway, I guess, as far as information about the claim.
Right, because they wrote it, right?
Exactly. Yeah, they wrote the policy.
Yep.
They've developed that relationship with the policyholder. Especially if we're chasing down a proof of loss, an agent's a great person to go to
Oh yeah.
to help facilitate that with the insured. Contractors is another one. We get a lot of contractors who are representing the insured. Maybe they had the insured sign an assignment of benefits, which is a form basically transferring the rights of the claim over to, or the benefits of the claim over to the contractor.
Right.
That's not valid under this policy. It's not valid per federal regulation. So
Right.
we can't recognize the contractor, mitigation contractor. We don't recognize AOBs. Now, can you have a conversation with the contractor? Absolutely. Like, absolutely. You can, again, educate them. You can, hey, I'm looking at your estimate. I have a question about line 16.
Right.
No problem. What you don't want to do with a contractor is disclose specifics about this particular claim that you're working.
Right.
You don't want to tell them, I've paid this much money to the policyholder. I don't know why they haven't paid you. No, we can't do that. But we can have, some sort of dialogue with these contractors. Unit owners. This is a big one. So if you're handling a claim for an RC BAP, that named insured is the condo association. And per their bylaws, the units, the unit owners and everybody who's part of that association gives the right to the board to handle their insurance affairs. So if you have a unit owner contacting you about an RCBAP claim, you can't disclose information. Again, it's a good time to provide some education, tell them about the policy, but you can't disclose information for the claim for the condo association to a unit owner. You can refer them back to their board or their president, because legally that is who is responsible for that particular claim.
Right.
And we're still seeing this a lot with Hurricane Ian claims. You all know there was a lot of condos that were impacted
Oh
with
yeah.
Hurricane
Sure.
Ian.
Yep.
Yeah. Family members, um, you know, you may have husband and wife, but only wife's name's on the policy. That's okay. The policy defines you as you and your immediate family members living in the household. So, not a big deal if husband's not on the policy and you want to talk to husband about the claim. He's covered under the policy. But maybe our policyholder is elderly and the son wants to get involved and helped. That's okay. We just need to get the permission from our policyholder in order for them to do that. Or
Okay.
maybe son's the guardian. Maybe there's some sort of power of attorney paperwork. No problem. We just want to get that paperwork so we're protected. And then we can have those conversations with the family member.
Right.
So, yeah, lots of different people get involved. Again, maintain the same level of customer service, the same level of education, but just familiarize yourself with these people, know who you're talking to, so you know what you can and can't disclose.
Absolutely.
Yeah. Yeah. So this next one is for both of you. We'll go Miguel first and then Elaine. We've talked about PA and attorney demands, right? But let's dive a little bit deeper into that. How do you handle and respond to the aspects when it comes to appraisal, mediation, those types of things?
All right, I'll take it first. I'll leave appraisal and mediation for Elaine to speak of.
Okay.
But I'll speak of other demands that we're receiving. So with the NFIP program, if a policyholder is not in agreement with their claim and they feel a need to escalate, there are several avenues and several points of escalation a policyholder could take. In a lot of cases, that's not happening. The escalation process on an NFIP policy is for the policyholder to reach out to their field adjuster, their examiner, have that conversation. If they feel like they can get anywhere and they want to escalate more, the next step is to reach out to the manager of those adjusters or the Write Your Own Principle, which is published on the FEMA NFIP website. That escalation to leadership will obviously escalate the claim, get another set of eyes on the claim, and try to try to take care of that escalation. If they feel like escalating more, if their claim was partially or fully denied, they have the opportunity to file an appeal within 60 days of the date on that full or partial denial letter. Once they file that appeal with FEMA, the FEMA appeals branch will request a file from the Write Your Own carrier. We'll look at the policyholder or the representative's complaint. We'll evaluate the entire situation and make a decision. Um, they'll say that if the claim was properly handled, there's nothing else to do, or they'll make a recommendation to work with their adjuster, the carrier, to work on items that still need to be addressed. If they want to escalate further than that, they have 365 days, a year after the claim has been paid, to file suit in federal court. I say it that way because the majority of the lawsuits we're receiving are in state court, which is inappropriate. It's costing a lot of money for our litigation team just to move these claims out of state court into federal court. Uh, Talking about other demands we're getting, which are very inappropriate and very popular, especially with Hurricane Ian. As we know, Hurricane Ian struck in 4 different states, Florida being where the majority of the claims were. In Florida, with the state, at the state level, with the State Department of Insurance, there's a process that's been in play for a few years now. It's called the PITL, a pre-intent to litigate. This is something created by the Florida Department of Insurance. Not the other 49 states have. It's only a Florida regulation. This gives, in the PMC world, not in the NFIP world, this gives an attorney, a public adjuster, a policyholder, like a last chance to try to resolve. It's like a 14-day last chance to try to resolve something before filing suit. That is the procedure with property and casualty in the state of Florida. That does not apply to federal or the NFIP. When I have these conversations with the law firms, they're like, well, it's our procedure to file a pre-intent to litigate notice immediately when we get representation just to get somebody's attention. I'm like, well, you're not getting anybody's attention. You're making improper demands and going to the improper agencies to file complaints. We're getting a lot of those PITLs. We're getting a lot of civil remedy notices. Also inappropriate. Just reviewed a civil remedy notice with 14 different Florida state statutes.
Wow.
It's completely irrelevant, out of jurisdiction, nothing we could work with. There's FEMA template letters to address those 2 types of complaints, to move those complaints out of the state and into the federal arena, or into the right way, the correct approach to deal with the escalation. Don't get me wrong. When we get these complaints, we don't just say you follow them in the wrong place, can't help you. We properly address them and send the proper documentation explaining why it's in the wrong place. But let's be honest with each other. They hired an attorney, they hired a public adjuster, they're escalating. So we get, even though it was filed in the wrong places, we still review those demands and look for those opportunities to peel the claim back,
Right.
see what they're complaining about, make sure all our bases are covered, and either address what's going on or use that as an opportunity to pay for something that was probably missed in the claim file.
Yeah.
So not a total waste,
Right.
But unappropriate.
Right.
Yeah. Yeah. Elaine, take part 2 of that when it comes to appraisal and mediation.
Sure. So a couple weeks ago, we actually got a mediation from the state of Florida. We got a notice that we were going to participate in a mediation, and here is our mediator, and where's ours? And I had to do a double take and look at the policy. There is no mediation clause in the flood policy.
Oh.
That doesn't exist. So we politely explained that to the state of Florida, and we were released from the mediation. But if you get demands for, well, we're going to mediate this, again, refer them back to the policy, educate them, because it doesn't exist in the flood policy. But appraisal does exist. Appraisal is something that's often used in the PNC world and can be very helpful in resolving disputes. The difference with the flood policy is that the appraisal provision can only be used to go over pricing disputes. It cannot be used to go over scope or coverage issues. So if we have a demand for appraisal, 9 out of 10 times we're going to reject it. We're going to explain that this is not going to resolve scope issues. The only way we can go to appraisal is if you agree to our scope. So I'll tell you a quick story. A couple years ago in Florida, of course, I did have a public adjuster and an insured who agreed to our scope and said we could go to appraisal. Okay, great. This is the only time I think in my whole flood career, like I've had this happen and we go to appraisal. So we're going to appraisal and the appraisers are mediating back and forth about the price of stuff. And the public adjuster introduces a garage door that was damaged from the flood, but wasn't in our initial scope. Right then and there, the appraisal is shut down. It's invalidated, even though that garage door was damaged. And we took it back and handled everything through the normal RAP process. But exactly what that adjuster writes on his estimate sheet, nothing more, nothing less, is what we can argue in appraisal. And we can only argue the cost of those items.
Yeah.
So, and again, Miguel mentioned this, anytime we get these demands, whether it be we're going to get an attorney, we're going to sue you, we're going to file appraisal, we're going to go to mediation, whatever it is, it's another good opportunity to just educate the rep or the policyholder or both and make sure that they understand, here's how the program works, here's what we can do for you, and here's what we will do for you as far as the RAP process goes.
Oh, absolutely. Aaron, how would you recommend an adjuster educate a PA on these issues?
Yeah, I think, just to touch on Elaine's point there, I think that goes back to the clear communication of the processes and educating the public adjuster, because what I've seen in my experience is that those demands for an appraisal typically goes away whenever they understand that we don't have to negotiate on the cost of an item. We can address the contractor's actual price.
Right.
And so there's really no need to go to an appraisal whenever they figure out that they can address the actual incurred cost. But in general on the claim, I think that as far as the educating the public adjuster, I think that really setting the adjuster on the claim, setting the tone from the beginning, that it's not like an adjuster versus the public adjuster.
Right.
I think it should be looked at as simply two professionals that are working together toward the common goal of getting the file closed.
Absolutely.
And when you have that working together mindset and sharing of information mindset, I think that typically it causes the claims to go smoother.
Mm-hmm.
If you take the time to educate the public adjuster on, like I said, the incurred cost documentation, we can address that, or responding to their public adjuster estimates and going over the coverage, what's covered, what's not, just taking the time, just like you would with anybody else, but just taking the time to create a team environment that you're working together toward getting the policyholder everything that they're owed. I think that usually creates an environment that's conducive to success of working together.
Oh, yeah. And to touch on that, when I was examining files and dealt with PAs and attorneys and they would bring issues to me, I would talk with them, but I would also take the part of the policy, or I would take the policy and highlight part of it, or take the pages from the claims manual and email it to them and recap what we talked about so that they had it in writing. They saw that it is in the policy. They see that it is in the manual. And I didn't do it in a here in your face way. It was, look, here's the information for future reference so that you have it. And when I did that, literally every time the communication with them became much more open, and they were much more willing to work with me, and we got the claim done much quicker. So I think going back to the putting things in writing, yes, send the documentation, because the policy is the policy. It's not, I don't want to pay for this, or I'm not going to. That has nothing to do with it. It is the policy will cover certain things and it will not cover certain things, and here they are,
Yeah. And also to that point, I think that, the adjuster should have the mindset of not just looking at the public adjuster or attorney's request and looking at it to see what I can deny in here, what can I say no on, But if you take the time to say, hey, maybe here's another option that you're not asking me for, but this is another way to get get the policyholder what they're owed, or work with them to not create a hostile environment, but to create a teamwork environment, to say, here's some additional options to get this claim more money, or here's some additional options to move it forward. So not just always having a no mindset and saying, what can we do?
Right. Yeah, good point. Elaine, this one's for you. You actually touched on it a couple minutes ago, RAPs, requests for additional payments. What are some best practices when dealing with those? Not necessarily a PA estimate, but the RAP in general.
Yeah, thank you for the opportunity to speak on this, because we are still seeing so many RAPs come through for
Sure.
Ian, as I'm sure you are on your end. And we've stressed this throughout our presentation. We need to be providing the best customer service we can, whether it's our policyholder or their representative. So a RAP is just another opportunity to provide good customer service. You want to treat the RAPs as the same urgency that you gave the base claim. We don't want the RAPs to just sit there. We don't want them to, like, oh, I'm too busy, or they've already got money, this can wait. Be proactive in working the RAPs as well when they come in, maintaining that communication with the public adjuster or the insured, whomever you're working with. From my end, from the carrier end, keep us informed. A lot of times we don't know that the policyholder has reached out to the adjuster, or a PA's reached out to the adjuster and started the RAP process. So make sure you're keeping the carrier informed as well. Again, we want everything documented and in the claim file. These claim files are discoverable, and it's not a bad thing if they discover, yeah, we knew you requested more money, and we've been working with you, and we've been trying to get there with you as well.
Right.
I mentioned this before, but we, go back to the great guidance in the claims manual about the RAP process. Just because a public adjuster or an attorney has submitted an estimate doesn't mean you just stop and say, nope, these aren't incurred costs. Yes, we will need incurred costs if we're going to change pricing, but we can still review those estimates from third parties like the public adjuster, attorney, consultant, for any omitted or missed items. And we're all human. Our adjusters are human. They may have missed something. They can review it for different quality of items. So maybe the adjuster put standard baseboards in all the room. The public adjuster's got 6-inch baseboards. Do a double check. Go back and look at the pictures. Oh, you know what? These were higher grade baseboards.
Right.
Yeah.
So there's a lot you can do with the public adjuster or attorney's estimate. We don't want you to just ignore it because it's not an incurred cost.
Right.
But review the manual, make sure you're familiar with the guidelines. And then again, we're going to keep preaching this. Like, this is just another opportunity to provide good customer service to our policyholder.
Right. Yeah. So Miguel, to kind of sum it all up, would you agree that ultimately it's all about customer service and providing the best customer experience for our policyholders? But even if the customer is in the form of a PA or attorney, we should still provide that good customer service.
Correct. Customer service is our top priority and should never suffer if there's a representative involved. Just want to emphasize, if there's a public adjuster or an attorney involved, the claim will be handled the same.
Right.
Coverage is not going to change.
Absolutely.
If we can't figure something out in a conversation during the regular claims handling or in a supplement, once this escalates to litigation, coverage is not going to change. FEMA doesn't allow us to just throw money at a case to make it go away. We're going to continue to have the same conversations. Whatever we ask for in the supplement process, if they ignore it and file suit, when we get to suit, two attorneys are going to ask, our attorney is going to ask the plaintiff's attorney for the same identical thing. It just becomes like an escalated supplement or a more expensive supplement from a legal perspective. So from our end, legal fees from the Write Your Own carriers are being paid by U.S. Treasury money. And from the policyholder's perspective, FEMA's not paying their legal fees. So not sure how those attorneys are getting paid. Are I don't think they're working for free, so it's probably coming out of policyholders' money. Poor policyholder, he already suffered a loss.
Right.
Right? He's already had a disaster in his home, already suffered a loss. Chances are items are not covered, which is why there's dispute and there's litigation. So they're out money. And now to be out money to an attorney or whatever settlement is issued, a portion of that money is taken by the attorney. That's just going to set the policyholder back. Nobody on this call, nobody on our team is afraid to litigate, but there's so many options before we get to litigation.
Oh, yeah.
1,000%. So we have reached the end of our Q&A segment. However, we do have some questions from the audience that we want to address quickly. Do some quick hitters here. We'll pose these questions to Miguel or Elaine. One of you can take them. I'll let you fight over which ones you want to take. So first question that we're going to have here. How do you handle when a PA demands a copy of the insurance company's guidelines? How do you handle that?
Give them the NFIP claim file or claims manual. Those are our guidelines.
Great answer. Great answer.
Public record.
Yeah, there you go. There you go. All right, next one. When you're teaching, or coaching, I should say, the PA or the attorney, would it be proper to send them a brochure so they can review and learn how that policy works? I think that goes back into our last question too, but I mean, that's appropriate, right? We can do that.
Yep. We do it all the time. It's all public record.
Yeah, good deal. All right, how about... Here's a really good one. How do you handle a claim where the policyholder has two public adjusters, okay? And they both have a letter of representation, and now the policyholder is a little bit confused on who's actually representing them. Do you see that happen?
We don't really see that happen. What we see is that you have a public adjuster and then they get an attorney,
right?
And they're unrelated, and we've got two letters of representation. Typically, in that case, we would communicate with the attorney and maybe put the public adjuster on copy.
Okay.
Right.
But we don't really see two public adjusters. And honestly, if I did, I think I would call both of them and be like, what's going on?
Right. So you would say the attorney supersedes the PA in that aspect.
Yeah.
Okay.
Yeah.
Cool.
Yeah.
You got to have those conversations, see how they want to handle it.
Right. Goes back to communication. 100%. Yep. Good deal. Yeah. Those are some good questions we got out of the chat. I know we didn't get to do all of them today. Do we have one more? Oh, one just came through. All right, so let's do this last one, and then we'll wrap it up. Question is, when people say that they are NFIP certified, what does that mean? This year I've watched the 6-hour video as required. Does that make them NFIP certified? How do they get NFIP certified? Maybe that's a better question.
Oh, I can answer that. Oh, go ahead.
Go for it.
Well, I mean, you have to.
Julie.
You need to go to FEMA's website and watch the webinar and fill out your application and send that in with your, the certificate of attendance.
Yeah.
And then they will contact you back.
Yeah.
Yeah, typically that takes a couple of weeks to come in after you watch the webinar, depending on how backed up FEMA is or NFIP is on getting those certificates out. But take the webinar, they'll email you a certificate of completion of that course. And then they also, I believe, included in that email is some instructions on, they'll send a blank application with it and then some instructions on where to email that back to.
Yeah.
So you attach your completed application and a certificate of completion together, email that back to them, and then
Yeah. Well,
they'll
I'm sorry.
either approve or reject.
Can you guys add the FEMA Adjusters Capacity Program too? How the different training and claims and certification to handle different forms?
What are you talking about from, go ahead.
Oh, I was going to say you would have to find a insurance adjusting firm that is doing the FACP and then go through them to do all that. If you have 4 years of experience in property, 4 years or more, you can take the webinar class and you can apply for your FCN.
Yeah.
So you just need that 4 years experience, or you do have to go through the FACP, that program, and you need to look into your local IA firms to see if they're offering that.
Yeah, good stuff.
I would like to thank everybody who joined us today. I sure appreciate it. The numbers are growing, and it's great. And Miguel and Elaine are two of my very favorite people in the whole wide world, and I love to talk with them. So I'm super excited I got to be involved.
Yeah. Aaron, any closing thoughts from you?
Yeah, same as Julie said. I appreciate everybody joining. I think it was a great conversation. You know, this is public adjusters and attorneys, and lots of things flood related is, always the flood program in general is something that's always changing, and staying up to date on those changes and procedures that we need to handle in the field. I think it's always great conversations to have, great information to put out there. So I appreciate everybody joining, and appreciate Miguel and Elaine joining us as well.
Thank you. It was a pleasure to have Elaine and myself as a guest speaker. I know we've done this in the past. Always very educational and always good information. What I love the best about the flood industry is how good we work together.
Yes.
And regardless of your capacity, if you're at a carrier, at an IA firm, engineering firm, we're always working together as an industry to make the NFIP program and process better and have a better experience for the policyholder.
I fully agree.
Yep.
Yep.
One last order of business before we wrap it up for our CNC adjusters. Make sure you click the link in the live chat to get your CNC points. If you're not on the roster, go to our website, adjustingexpectations.com, to sign up and do an application so you do get on the roster for any potential claims, deployments, things like that. So again, I'm echoing both of these. Miguel, Elaine, we greatly appreciate you being here. I know you both are extremely busy, so we appreciate you taking this time out of your Thursday to do this with us. Appreciate all of our attendees for being with us today, all the people behind the scenes that you don't see that make this broadcast possible, and we hope to see you next time. Thanks, everybody.
Bye.
Thank you. Thank you.